because you get endless spam messages from me. Okay, a quick word about that. I am the chair of the BCS ISSG. I've only been the chair since last October. I've actually been on the committee for about 25 years. But my view is, and always has been, that all IT professionals ought to be concerned about security, whether or not they're security professionals. So we tried to do something about that, but we only have 4,500 members, and BCS has 70-odd thousand members, so we've got a long way to go. But I'd encourage you to join if you felt like it. So what's my sort of background for GDPR, and why can I talk about it? Well, I was for a long time a member of the Information Privacy Expert Panel of BCS, which previously was called something like the Data Protection Forum. So from about 1998 till its demise last year, when they decided to change how they were doing things in BCS, I was a member of that panel. I've also, because I'm a consultant, hence the fear, uncertainty and doubt, because everybody knows that's what security consultants try to sow to sell their wares. As a consultant, I saw that this was going to be a great opportunity, so I got myself certified in various ways. I'm a certified data protection officer. I'm a certified information privacy professional / Europe, and a certified information privacy manager, which is proving to be quite useful for getting jobs. But fear, uncertainty and doubt is something that I don't particularly want to spread. So there were a lot of, originally in this thing, I had a lot of slides about data losses, which of course we've had lots of over the last few years, and they've changed, and the climate has changed a bit as well as to how they're dealt with. But I thought I'd be topical because now, of course, you're all getting deluges in your inboxes of people trying to get you to let them stay in contact with you in various ways. Not all of which are very good, by the way. They don't, and you'll probably at the end of this, hopefully at the end of this, you'll see why some of them aren't any good. But things like Uber, Madison Lee, et cetera, all had their big problems over the recent years. And it's a big issue, and it's going to get worse with GDPR for a lot of these people if the regulators choose to do something about it. So, this is the fear, uncertainty and doubt that people use quite often. 20 million euros, which is about, I think, about 17 million pounds at the moment, or 4% of the global turnover, whichever is the larger. That is the maximum penalty for certain types of infringement. But it's always been recognised, and certainly by the regulators, that that is not the way things are going to be done, necessarily. It might be for a very big company, which is doing something really bad, but for your average company, you'll start with a slap on the wrist, which of course is publicised. So therefore there's reputational damage. Depends how you mark out reputational risk as to what actually that means to you. And this is what the ICO, our regulator, says about it. So that's more or less saying what I just said, I think. That's official from the ICO blog. Doesn't want any scaremongering, but does want the greater powers. So, I mean, it's a risk thing. The whole thing is a risk thing. It's all about how you balance out the potential for damage to your organisation with the law and what you do. But it is a risk thing, and we'll see, we'll have risks and benefits from this. A lot of people are saying, a lot of the more enlightened consultants and people in this field are saying that it gives you benefits because it'll give you a competitive advantage if you're really, really good at protecting people's personal information when you are using it for your own benefit. So, what sorts of risks are we talking about? Well, here's some of them that we might think about. Interestingly, one of the things about personal data, of course, is that most organisations hold it on their own employees as well. So that one there, loss of employee trust, is something which people often don't think about. Operational, this, if they have a right to do things like that, unless you've built privacy into your systems right from the start, which of course in legacy systems you almost certainly haven't, because even if you were trying to follow the DPA was not a good reflection of what's in the GDPR, except insofar as the mechanics of it. The actual underlying thing with GDPR is not represented there. We'll come to that in a minute. So data breaches, obviously you now have to do lots of things, that'll be a risk. Financials, we've talked about that, but it's not just the fines, it's litigation. Some people are going to litigate against you. There is actually talk about them being able to bring class actions in for major loss of data. So that will be quite something. And remediation costs. You know, if you're in a situation where you have had a big breach and the ICO or whatever regulator it is, and I'll tell you an interesting story about that in a minute, comes in and says, well, you've got to do something about this, then you've got quite a big cost to remediate things. Probably a huge cost in some cases. And then regulatory, you've got the regulator has now got themselves in the UK law, which I'm going to talk about later as well, the right to conduct audits, no notice if necessary, obtain access, etc., etc. So there's a lot of risks out there which you've got to balance up. Now, I've made a couple of sort of off-the-cuff statements. So, by the way, please, if you want to ask a question as we go along, it'll probably be answered later, but if you do, it'll be useful to just interact as we go. But one of the off-the-cuff remarks I've just made is that the Data Protection Act that we currently have, the 1998 Act, which some people have said if you're compliant with, you've got a very good start for GDPR, and that is true in a lot of ways, but there are some big differences which we'll come to in a minute. But the point about the UK law was built on a directive of 1995 from the European Union. Now the directive has a lot of material in it which is to do with human rights. And the UK government, of course, stripped all that out. Don't like human rights, don't like that sort of thing. So that was stripped out. So it's actually a sort of slightly hollow, the current Data Protection Act in that sense. And it's one of the reasons, not for the UK in particular, but for other countries as well, because it's been done differently in every country in Europe, just about, that directive. A directive has to be imported into our law, or into the law of each of the countries. But a regulation can just, as it stands, be law over the whole of the Union, which is what's going to happen in 11 days' time. That regulation is going to be law. We may have put our own Data Protection Act into place, which incorporates all of GDPR and more, as I'll discuss later, but we may not. And if we don't, then GDPR itself will be law, because it's a regulation, so it applies to all the Union. Now, what does this mean? Well, what it means is, and this is the basic principle that you need to use every time you're thinking about GDPR, what that means is that the very heart of it is the rights and freedoms of the individual. That's what's at the heart of it. Not something corporations normally care about very much, but that's what at the heart of it. So all of the sort of things that you have to do come back to that. Except there are, of course, exceptions to that, like national security and things like that, but we'll go into those later. So what I've done is I've added a section onto the end of this to talk about the UK Act as far as we know it at the moment. It's a bill at the moment. It's changing all the time. It's going through the houses. It's getting amendments made to it. So this is just a general overview of some of the things that are being done in that as well, on top of what's being done in GDPR. Because actually, in some ways, the UK has actually extended GDPR in their bill. which is interesting. You know, we've become super over zealous, if you like, probably in the hope of getting adequacy. Now, I don't know if you know what that is, but basically, if you're not a European Union nation, then in order for data transfers to be possible across borders for personal data from the EU nation to you, you need to be declared adequate, which means that your laws are at least as good as the European Union ones in the European Union's eyes. So there are some countries that have adequacy at the moment. Strange mixture. Argentina's one for some reason, but there are not that many of them actually at the moment. There's a few, and we will probably have to gain that status. Right. So what are the principles of GDPR? These are core principles. Underpinning all of them is accountability. So organizations have to show that they are complying with the regulation. They have to be able to show that they're complying with it. I'm going to introduce a couple more terms here. Data controllers are the people who decide what the processing of personal data is going to be and how it's to be done and all the facts around it. Data processors are people that they may use to process that data. One of the big changes, and we'll come to this later again, under GDPR is that data processors, which used to have not that many responsibilities under the old directive, Data Protection Act 1998 in effect, now have a lot more responsibilities, as does the combination of controller and processor. We'll talk about that later. But accountability applies to all people processing it. So it applies to the data controller in particular, but it also applies to the processor. So if somebody's processing data on another's behalf, they have to be accountable for what they've done. And in particular, they have to be accountable that what they do is recorded and is in accordance with the detailed instructions that are given by the controller to the processor. And that detailed instructions thing is a big thing which is missed out in a lot of talks you will hear about GDPR. It does affect processors, the processor-controller relationship quite drastically. So what are these things? The core principles. Purpose limitation. To put it simply, data shouldn't be used for uses other than that which you've told in transparency, because transparency is a big one. You've told that the data subject is going to be used for. Integrity and confidentiality, you've got to look after it. You've got to make sure it is secure. Data minimization, you don't use, there are long legal sort of words in the GDPR about these, but what these I'm giving you what they actually mean. Data minimization, don't collect any more than you need. Storage limitation, don't keep it any longer than you need to. Accuracy, make sure it's right. And if somebody tells you it isn't right and it's their data, i.e. they're the data subject, it's one of their rights to have it corrected. It has to be lawful, it has to be fair what you do with it, and it has to be transparent what you're going to do with it. Now these principles apply regardless of the legal basis of processing. We'll come on to legal basis of processing in a little while. Some of the rights that an individual has are lost under some bases of processing. But we'll talk about that as we go forward. The other interesting thing about it is, I'm sorry about the colour of these, it doesn't work very well, does it? Look great on my screen. So, what's in scope? Automated and manual processing of personal data. So, where does that apply? Well, it applies if any of those three things at the bottom on the left-hand side as you look at it are in the EU. So if the organisation processing the data is in the EU, GDPR applies. If the data subject's in the EU, regardless of where the data is being processing, the regulation applies. If the processing itself is done in the EU, it applies, even if it's being done by an organisation which is not an EU organisation, if it's being done in the EU. Out of scope, your own personal stuff, as long as there's no connection to a professional or commercial activity, so that rules me out because almost everything I do is related to some sort of commercial part of me, and I'm a one-man band. Deceased persons or legal entities, they don't count. And also there are things under law enforcement, national security, public security and immigration which don't come under GDPR, out of scope. Also out of scope of GDPR as it stands are things which are not within the competence of the European Union. So, obviously those are things which are not within the competence necessarily. Immigration I'm not so sure about. But an interesting example that was posited to me recently by a lawyer, a very well-known and well-respected lawyer in the personal data field, was that a lot of health data doesn't actually come within the remit of GDPR. Data about drugs does, because as you're probably aware, there is an agency which actually sits in Canary Wharf at the moment. It's just considering where it's going to move when we leave the union. But they regulate drugs. So drugs and things like that do, but other things don't necessarily. So that's one of the things that's being taken care of in the UK bill, as you'll see later on. So what are the major changes? We'll talk about some of these. We just talked about the wider geographic scope. This is from the directive, by the way, changes from the directive. So the directive was not as didn't capture as wide a geographic scope. There's a lot of changes around consent. Consent has been better defined. It now, under the old directive, it was assumed that you'd want informed and positive consent by the people who wrote it. They've realised with history and what's happened since that isn't the case. So it's been much more tightly defined. Privacy by design, they're saying that's what you should do. Well, this leaves legacy systems in a lot of difficulties because the regulation is written as if privacy by design has always been there, and it hasn't. Right to erasure and also right to be forgotten, which are not quite the same things. But it's interesting, in the GDPR, the right to erasure actually comes in. The GDPR is arranged in a series, those who've looked at it see it's arranged in a series of articles, about half of which actually deal with how it's going to be managed, interesting enough, in between regulatory authorities. But it's a series of articles. Then there's a series of recitals which go with those articles, which give a little more detail, a little context and that sort of thing, all of which are part of the regulation. The articles only deal with the right to erasure. Right to be forgotten only occurs in a recital, therefore it's slightly less sort of in your face, but it means that you not just have it erased on your own system, but where you've shared it with other people, possibly or probably, if you've been obeying the regulation lawfully, you have to go beyond and try and get them to get rid of it as well, that data. That's the right to be forgotten. It's an extension of the right to erasure. The right to erasure, we're going to talk about legal bases for processing in a minute, but the right to erasure only applies to where the legal basis is consent. You'll see that there are actually 6 legal bases, and all the others, it doesn't make any sense for it to apply, as you'll see. But it applies where you have to rely on consent, which makes life very difficult for people who market via emails and things like that, because that has to be based on consent. Fines, there are fines now, they're much bigger than they ever used to be. There's a need for data protection officers in certain types of organisations, basically all governmental organisations, and a lot of other large companies will require data protection officers, and even small companies where there is a high risk of harm to the rights and freedoms of individuals. So I can think of an example. I came across a firm last year which was quite a small firm. It's hardly even a medium-sized enterprise, probably about 50 or 60 people. But it was doing data analytics. It wasn't Cambridge Analytica. For about 40 or 50 medium-sized and above enterprises, going up to lower-end FTSE 250 type companies. And they were processing one hell of a lot of personal data. So they, I would say, would need a data protection officer. Breach notification has been tightened up. Data transfer has been tightened up. These are the big changes. The other big change that isn't on this was somebody else's diagram that I've already mentioned, is the processor-controller relationship, which actually I think is huge. So, what was I going to say? I was going to say something there. Can't remember. So the legal bases. There are 6. As you can see, this business about erasure and some of the other rights and freedoms, which we'll come to later, doesn't apply, only applies for consent. Because the others, there are other reasons. Now, some of these sound a bit sort of vague. Legitimate interests. I mean, what sort of claims could you make about that? You know, you could always say, well, of course, it's my legitimate interest as an incorporated company. I need to make, I need to do my business, which is whatever it is, and I need to use personal data for that. So it's a legitimate interest. So I don't need to get consent and all this sort of thing. Okay, so there's 2 things to say about that. Firstly, the people who drafted all this have been very wary about this. So these other ones, for example, let me give you an example. The biggest example is, you might think that legitimate interest is what governmental bodies would use, but they're not allowed to. It actually specifically states in the GDPR, you cannot use legitimate interest. Public interest or vested authority, yes, you could perhaps do that. But of course, under all of them, if you remember right back to starting point that I said, which was that the rights and freedoms of the individual are actually at the basis of everything here. That is protected here. So even if you're doing it under something other than consent, if you're doing it under contract, you still have to be transparent. So the regulation still says you have to be transparent. You have to tell people what data you're collecting, what you're going to do with it, how you're protecting it, how they can complain, who they can go to, who the data protection officer is or the equivalent person within the organization, what their rights are over that data, that they can have it modified, that they can gain it from you in a machine-readable format, in a sensible machine-readable format as well. All these things are in the GDPR, and they apply to all of these bases to some extent. Not completely. The only one they apply to completely is consent, but they still underpin it. So if it makes sense, it'll still underpin it. That's probably the best way to think about it. So here's my little hobby horse about processes, and the reason I've got quite a lot on this is because it's often not talked about, but it is actually quite important. So one thing it does is it directly regulates data processes. That's not happened before. They weren't directly regulated. They were regulated via the controller. And that's the sort of things that they have to do. But the big thing is the second major bullet down there after the sub-bullets under the first set, which is the controllers must ensure there's a written data processing agreement in place which meet the requirements of GDPR. So, what that means is that, let's say you're in a legacy situation where you've been processing personal data on behalf of a controller for many years, and all of a sudden, and you've done it under a fairly generalized contract. things have changed over the years in what you've been doing. You know, you've made changes, because in any business, any organization, as you go forward, you find better ways of doing things. But of course, you might have had quite a good description, if you were lucky, of the processing you were doing right at the beginning. But as things changed, that tended not to happen. The documentation tended not to be upgraded, etc. You could find that you are, on May the 25th, in breach of this as a processor. So there is an article about, I did want to get a set of the thing up on the thing, but there is actually a very good version of GDPR which you can find quite easily. It's called Neatly Arranged or something like that, and it has the recitals attached to the appropriate articles. There's an article late in the document in GDPR which says, effectively, if a processor goes outside what he has been explicitly told to do by the controller, he will be considered to be a data controller. Now, why does that matter? Why that matters is that if you're a processor and you're following religiously what you've been told to do, and you're meeting all these requirements, your maximum fine and everything that goes underneath it, from the slap on the wrist up to, will only be 2% of your global turnover, or 10 million euros, whichever's the greater. So it's half. So you'd be considered to be half of what you would get if you were a controller. But if you are doing something which is relevant to whatever the breach is, or whatever it is that you're doing that's wrong, that's outside what you've been told to do by your controller, then you are deemed to be a co-controller. Now that is very significant for processors. And I should know, because I've been spending about a year and a half now trying to persuade a government department to properly describe the processes that a processor that I happen to be working for at the moment is doing. And it's almost impossible. So what are those individual rights I've talked about so many times? And these underpin a lot of this. Right to be informed, that is always true in all of the legal bases. Right of access, that is nearly always true. There are certain cases, perhaps in criminal data and things like that, where it's not necessarily true. But in almost all cases, you do have the right of access. So you have a right to make an access request, and you have to be given that data within quite a short period of time. Now it's been tightened up again. That one's been tightened up as well. Right to rectification. If you notice when you've had your access that something's wrong, then you have a right to have it rectified. Right to erasure, we've discussed that already. Right to restrict processing. So if you feel you've been misled somehow, or you didn't really understand when you read that clear and unambiguous privacy notice when you first joined up to something, and you want to change your mind, you can restrict it, because you might have signed up to something you didn't mean to. Right to data portability, you should be able to, this is in particular the cases where people are holding personal data to do stuff with, you want to move to something else, to some other organization to do the same or similar thing. You have the right to have your data, have it portable, and have it in a form that can be read by the new organization, so something widely used. Right to object to what's being done with it, you always have that. And then there are a number of rights related to automated decision making, including profiling. So once you're in the realm of profiling, the GDPR gets very strict about what can and can't be done, and how much consent you need to give. You need a lot of consent for profiling, which is a bit of a shame for people like Facebook, Google, etc., Amazon. But there you go. There you go. I'm sure they'll find ways around it, because they always have in the past. So where can we find stuff that's useful? I've updated this recently because there's new stuff coming out all the time. It's been very slow, and given I'm going to show you in a while a timeline which the ICO themselves said we should be following, and given that timeline, the speed at which they've put out guidance has been remarkably behind the drag curve, as we used to say. So there are some good stuff in there, though, in the ICO's stuff. So the guide to the GDPR I find the most useful thing, and it's linked to the Article 29 Working Party guidance and documentation that comes out in opinions. Now, the Article 29 Working Party is going to disappear in a few days' time because it's going to be replaced by the data, I forgot what it's called now, the Data Processing Board or something. It's the same thing. What it is, it's a group of all of the regulators from the union who sit together and work out what all this stuff really means, and then comes up with guidance and that sort of thing. It's a very useful website to look for. It's written in real Europeanese, but it is actually pretty good stuff. And the ICO is now linked to it. Now, what they put out recently, in the last 4 or 5 months, privacy notices, code of practice, consent guidance, guidance on legitimate interests. That's a very important one. I think people need to look at when they're looking at what basis they're using for their processing. There's a thing, another one of that, lawful basis guidance tool. There's a link to the tool now in there, which I haven't looked at yet because I only found out about it yesterday. But I think it's going to be quite interesting. I don't know what it'll do, but I'll have a look at that. And then they have these blogs. I gave you a quote from one earlier on, which is, they've been a bit quiet recently, but I assume there'll be a lot of noise around the actual 25th of May. So these are the ICO steps of GDPR. That's what they think you should do. That's the 12 steps. Is there 12 there? 1, 2, 3, 4, 6, 7, yeah. So these are the things you should do in the order in which they think you should do with it. That you should do it. So what they're saying is, go through those steps, and you go through those steps and you'll be happy. Obviously, you're down the bottom somewhere at the moment because it's all happening in 11 days' time. Yes? No? No? Okay. More regulatory guidance. I told about the Article 29 Working Party. They have just, since December, they've put out all of these guidances. And that's quite a lot of it. Quite a lot of useful stuff there. And they're looking at high-risk processing because there's a lot of description. There's a lot of stuff in the GDPR that says you have to do certain things if there's a high risk, like data protection impact assessments. It says if there's a high risk to the rights and freedoms of the individual, you have to do data protection impact assessments. But what's a high risk to the, where's the boundaries? And that's the sort of guidance they're looking at producing at the moment. And the certification thing is that they're looking at whether it's going to be possible for organisations to certify themselves like ISO 27001 certification, so that they can attest that they are a good organisation for doing this. That's regulatory guidance. So here we are again with the controller, processor, sub-processors, contracts. Just a few thoughts of what, and all of this will be available to you, by the way, after the event, if you wish it can be sent out. Is it too late? Have you done your due diligence? Have you really documented the responsibilities of the controller, the processor, and sub-processors? Do you know what the strategy is? Article 82 is the one. Article 82, that's the one I was talking about earlier, where it says that if a processor isn't following the precise instructions it's received, i.e., it's determining the means and the methods and the end points, then you are a controller. That's what Article 82 says. And what about the sheer volume of it? This is all, I think I first put this slide together nearly a year ago now, and I've still had too late. I think, now, if you haven't done all that, if you haven't done that work in contracts between yourself, processes and sub-processes, then it is too late. I have to hope for the best. Right, profiling and automated decision making. So, I think the most important thing about this is a lot of people do this, there is automated decision making, and there's been quite a lot of controversy about it. There's ethical questions about certain sorts of automated decision making, but it's coming to us more and more with AI and all that. It'll come in the health field, it'll come in automotives and transportation, it'll come all over the place, and it comes, of course, in decision making. But there is a right, which is a different right from the ones that are in the rights and freedoms of individuals that are in that article, not to be subject to the decision, to be informed. Whoops, sorry. So those ones at the bottom there, you need to consent, you need to be able to have that decision looked at again by human beings. That's the right to not to be subject. You need to know what's going on and be informed. So you need to have access to be informed. So that's quite a big thing for companies which use automated decision making or profiling. It's a big, big application of transparency to what has been very murky up to date. Yep. Absolutely. Yep. Yep, that will be part of it. Well, how it'll work out in practice. One caveat I want to make about all this, of course, is in advance of the event. As we know, cases make what actually we end up with, and there is no case law yet on any of this. So this is just interpretation, really. And the interpretation is based on those basic principles that I talked about right at the beginning. The fact that this is about the rights and freedoms of the individual, it's about transparency, and it's about the individual being in charge. So we don't know yet, but when you think about this for a short while, and it's worth looking at the articles that are concerned in this area, and they're quite short. It's going to be very interesting for people who do this for a living, of which there are quite a few these days in the modern world. It could do. It depends to a large extent on the legal basis of what they're doing, and that's an interesting question because it may be under a law, but an awful lot of what our government does is under the royal prerogative, which is not law. So that's an interesting question. I think that's something that's going to have to work out. Mm-hmm. There will be automated decision making, absolutely, and it will be clumsy because it always is, especially with government organisations that can't afford to do it as well as perhaps your Facebooks or whatever can do it. So there are going to be a lot of cases in this area, and I think what may well happen is, depends how the law sort of the legal system works out, because it is independent, the judiciary is independent. It depends how much they allow and how much they don't. But I think it's going to be a very interesting time, but that's a perfect example of what I was saying earlier, that we don't actually know yet. We know what it says, and it's quite vague in places. It seems like it isn't, but actually, what is high risk? What is risk? What is, there's those sort of phrases which have been absolutely defined or delineated. So it's going to be interesting.
Automated in this context mean only machines, or does it include sort of humans performing algorithms? Following protocols or following guidelines, and just going to be
It depends whether they have any free will or not. But again, that hasn't been defined to that level within the GDPR. So it's going to be a matter of finding. But if they are just blindly following rules, then why are they doing it anyway? Why haven't we got a machine doing it? Right. Another thing which you noticed in the changes earlier on was breach reporting. So what is a breach for personal data anyway? Breach of security leading to the destruction, loss, alteration, unauthorized disclosure of, or access to personal data. So it's not just losing it, it's actually letting people into your system and that sort of thing as well. So you don't have to actually lose it to have a breach. A breach is a breach. It goes, it's just been breached. Now this is one of these things where you get this risk and high risk. Look at the first two there on the right hand side. See? So what does that actually mean? What is the difference between risk and high risk? Where is that boundary? We don't know at the moment. You can make a good guess, and a notifiable breach, if it is notifiable, so if it's likely to result in a risk to the rights and freedoms of the individual, which most personal data breaches probably would, then you have to report it to the relevant supervisory authority within 72 hours. So what this actually means is that if you have a breach, you have to report it to the relevant supervisory authority within 72 hours. Only if it's a high risk do you have to tell, whatever a high risk is, do you have to tell the people whose data it actually is. Quite an interesting sort of conundrum, really. The other thing about relevant supervisory authorities, let's say you're a very big processor who is multinational. You'll have a headquarters somewhere, and your headquarters may or may not contain your data protection officer. Your data protection officer may be somewhere in the EU. Say you're American, for example. Say you're a big American processor. You have placed all over the world. You've decided that you've got to have a DPO because you're so big and you deal with a lot of personal data. And your DPO, you decide to put somewhere in an EU state because, it is the GDPR after all. That's what you're trying to work with. And you've got a lot of work in Europe, so it's important to you. Your big problem there is that the DPO has to notify and work with their own regulator. So let's say you had, I don't know, a government contract in France, and your DPO was actually based in Germany. Then it won't be dealt with by the French regulator, it'll be dealt with by the German regulator. Could be interesting, etc. Spain, Italy, whatever. It's wherever you happen to put it. So that's an oddity that's come out of the GDPR, possibly. So where do the risks come in breaches? Well, obviously from many directions, but to the organisation, you've got business interruption, remediation, you've got compensation, likely. And compensation that's another thing with Article 82, which I mentioned earlier, that individuals, if they can demonstrate that they have, what's the phrase now? It's basically tangible or even intangible harm come to them, i.e. it's mucked up their lives, or they feel they can show that it's made them a pariah in the local society or whatever it is, they can be compensated, they can claim compensation. So compensation is a reality in GDPR. And that's where the old class action thing's coming in as well. And then regulatory, obviously. Your reputation would suffer greatly.
Would the compensation come via the regulator rather than the individual?
I think yes, I think the regulator, I'm not actually sure how that works. I don't know. I've never thought about it. So I don't know. Apologies, I can't answer that question. I'd only make it up if I tried to. I'll have a look at it though and try and get back to you afterwards. So, what would happen if you were being audited by the ICO? And remember, under the new Data Protection Act, they can audit as they see fit. Might give you a bit of notice if you're lucky. What have you got to do? Well, you've got to show that it comes from the top down, starting over on that side. You've got to have your contracts to hand because, as we've already talked about, you know, that contract flow. If you're the controller, you need to show that you're contracting your processes, that you've seen the subcontracts from the processes to sub-processes, etc., and you've approved them because you have to under GDPR if you're a controller. If you're a processor, you have to show that you've been properly contracted by, etc., etc. System security is a big issue. You have to evidence that. ISO 27001 might be helpful, providing its scope is the same as the scope of personal data. And of course, we all know that ISO 27001 can be de-scoped to such an extent that you only get it for certain bits of your organization, which are easy to do. I speak as an ISO 27001 lead implementer and lead auditor as well. So that needs to be properly evidenced. Sorry. Shall we? In there, we can hear you.
Okay, the contracts to hand. If there's an existing contract that mentions the previous Data Protection Act, does it have to be updated?
Yes, afraid so. I'm afraid so.
Processor data and that's all agreed. If one department goes to another department and asks for data to be processed on their behalf, does it have to be an internal contract within the organisation?
I don't think so. I think that would be taken care of by, as long as you're processing within what you've been authorized to do and instructed to do, it really is that detailed. It has to be a detailed, you know, where your processing starts, stops. If you transfer it off to somebody else outside your organization, how that works, where it stops and starts, and all that has to be agreed and stated by the controller. Then what you do inside your own organization, as long as it meets that and is properly recorded, because you have to record how you process stuff. I'm not quite sure what that means, by the way. We're wrestling with that at the moment. But you do have to have a record of what you've done as well. So that is, yeah, you don't have to do that, no, as long as it meets the contractual arrangement with the controller to yourself.
Okay, so these points that the ICO might audit, are they also points that you as a data controller can audit on and kind of form part of these new contracts?
Well, if I was a data controller and I had a big processor who was processing personal data, I would want to audit them. In the contract, I'd want to have the right to audit to all of those things. Yes, absolutely. Would make sense.
I'm just thinking if I've got an agreement with, because you're talking about kind of multinationals, if I've got an agreement with a data processor who maybe doesn't have any sort of UK legal entity, we set out all of our contracts, but either they have a disclosure or they go out with the bounds of the processing agreement that we had. How does that get pursued through GDPR? Because they're processing European subjects, and we're obviously based in the UK.
You'd be the one who got it.
That's so even though we've set up our contracts, even though
yep, absolutely,
they are
because
PCI compliant and they're
they'd have to be adequate if they were outside the EU.
Yeah.
And you would be still responsible for that. You're if you're the processor, if you're the controller,
yep,
you are responsible for it wherever it goes. If it's data which is within the scope of GDPR. If you're the processor and the controller, and you will then have to, and I haven't discussed this, but if you are going to use sub-processes somewhere else, then that has to be transparent to the controller and has to be agreed by the controller what you're doing. So the controller then takes liability for that if it's a problem. But there are ways of getting around this. You can have, for example, large companies where they process, a lot of this happens a lot, where personal data is processed in the States, even though it's from here. They have things called binding corporate rules, or they're possibly under which have to be approved by the regulators, etc. So it's a very complex thing. But if it's in scope, then you, as the controller, are responsible, and it may be that the processor is responsible, especially if the processor has done it without the approval of the controller.
Even if you've done your due diligence,
yes,
as much
absolutely.
as and they have some sort of breach.
That's only an enabling factor, not a.
Right.
There's one over there.
Where there's sharing of data handling, for example, an online payment, somebody may be booking, let's just say, a course. You're collecting data on that particular individual. You're responsible for that data, that I understand. When you then go to the payment page and they're taken to, let's just say, for argument's sake, WorldPay, where does lines of responsibility end for you, and where does it begin for WorldPay? Or is it all under your responsibility because you've taken them to that portal?
This is one of those areas where it's going to be interesting to find out. But my belief is, and this is only my belief, and there's no cases to back this yet because we haven't actually got there yet. But my belief is that providing you describe the processing correctly, then when you hand off that data, well, it's not you actually that's handing off the data, is it? The data subject is handing off the data to that right, yeah. Payment portal. Yeah. So they effectively, what it means is you have to give your privacy notice. You have to say what you're going to do with the data, and part of that would be you'd be saying, well, we're going to use this payment portal. You then have to, and if you were a really good privacy notice for your own company, you'd be saying to your customers, and please read the privacy notice of that portal before you use it, because they are then responsible for it. That's how I believe it is. Can't be absolutely sure though, because it's nothing like that's come to thing. But that's how I would see it. So, if you can evidence all that, the ICO will go away happy. It's quite a lot. Of course, I'm a bit of a crisis and instant crisis disaster nut as well. That's worthless if it isn't practiced. So if you've got a crisis management team, you've got to exercise them. You've got to. Yes.
I have one question, and hopefully the answer is no, because I can't think of anybody else to ask. LinkedIn groups. I manage a LinkedIn group, and people ask to become a member, and I have to allow them.
Okay, so we've looked at this. If any of you are chairs or committee members of BCS specialist groups or branches, you will recently have received some guidance notes on how to conduct your business under GDPR. The guidance, it's called a policy and procedures document. When I first saw it, because I saw it in advance, because of where I sit, I was horrified by it, and I've made an awful lot of changes to it. So quite a lot of it is down to me, unfortunately. But one of the things that we discussed when we're doing that is that BCS cannot be responsible for what goes on LinkedIn groups. So I'm afraid it's down to you. It really is. I am actually a moderator on a LinkedIn group. I'm probably going to stop doing that soon, just for self-preservation.
That's just what I was thinking. I'll just close down the group. Thank you.
However, LinkedIn groups may not be something the regulator goes after very early. But of course, the big unknown in all this is what I've heard called the 3 C's, and I've got to remember what the 3 C's are now. No, the big, I'll just have to do it a different way. The big unknown is this, but I suspect it's going to be very big on all organisations is people who are crusaders or just troublemakers who will get hold of some things which are easily available on the internet and are very good. There's something called the nightmare letter, and there's another thing called the nightmare email. In fact, it's not called nightmare email, but essentially that's what they are. And I can send them out to anybody who wants them afterwards if they want to have a look at them. Essentially, they're very good guides to the GDPR because they're a letter purporting to be written by somebody who's worried by the fact that there's been the latest breach, and they want to know what's happening to their data. So they ask all these questions, which actually is a trot through the GDPR, and you have to answer them. So that's going to be quite difficult. So there are going to be people who do that because there are crusaders, there are troublemakers, and so I think there's going to be a positive deluge of requests of that nature just after the 25th of May. It probably will ease off eventually. The nightmare email is for people who do email marketing, which of course is an even more difficult area in this way.
I think it was reasonable to expect as well that there will be journalists out there stress testing institutions.
Yeah.
A league table of,
Yes, let's start again.
A performance league
Start
table.
Again, start again.
Yeah, I think there'll be interested journalists out there looking to stress test institutions for a league table of those who comply and those who are maybe not quite there yet. And now that the barrier of the personal data subject access request, the £10 barrier is down, if you don't know where their data is and you can't respond to that in an elegant, efficient way, then that's just very public, isn't it?
It certainly is. And of course, they have every right, if you don't respond correctly, to go to the regulator and say, these people. And mind you, the regulator is going to be absolutely overwhelmed as well, because when you think about it, they're very understaffed right now. They're trying desperately to recruit more people. I think they've just received the ability to go outside normal civil service pay systems to try and just get more people because it's difficult.
Can I make one more point there as well? Under the current system with the ICO, where an individual approaches them and says they are concerned that their data is not being processed correctly or within legal guidelines, the onus is on the subject to actually evidence that to the ICO for them to make an investigation. And for what I understand, on the 25th of May, that just gets turned on its head. The ICO are assuming everybody's guilty of everything.
I don't think it'll be quite like that, but you might be right, but I don't think they'll do it because of various reasons. And one is, and which is why this nightmare letter is important. Actually, you know, it's an extreme example, but the fact is that if anybody does ask an organisation for their personal data, and they don't get it according to the GDPR, which will tell them where they put it, who it's shared with, all that sort of thing. I mean, I don't know if any of you use PayPal at all. Have you? They didn't actually tell you, but I found out by another route. They have recently issued a document that says everybody they share data with, various sorts of data. And there's 600 different organisations, in excess of 600 organisations, on that list. And this is part of trying to be transparent for GDPR. It's fantastic. It's really quite an eye-opener to read it. I'd search it out if you're a PayPal user and see whether you're happy. I wasn't unhappy with it, actually. It seemed okay. But so there we are. Right. So here's a countdown that I got from, I think this was from Barclays Bank. Of course, we're about here at the moment. So I hope you've done all that. And this is an example process from one law firm, which I actually don't think is very good, but I use this for an example of how even law firms could get it wrong. So that's in your stuff that you'll be getting. So let's go on now to the UK and what we've done. So we have, it'll be an act, hopefully before the 25th of May, but if it isn't, GDPR will be as it is anyway. But it does a lot of things. The other big thing is the Law Enforcement Directive. So a law enforcement directive which needs to be, it's a directive, so it needs to be put into law over all the countries. And it's about, it's the relationship of law enforcement to personal data. GDPR also only within EU competence, we've already talked about that. So member states have to address those areas outside EU competence, which includes national security. And then there are these things called derogations. So the GDPR is hard fought. When it first came out in the first draft of it came out in end of 2011, beginning of 2012, the Commission thought they were going to get it into law within a year. And they had this big celebration in Brussels where they were going to unveil it and invited all sorts of people there. I was there, and it was the most amazing bun-faced bun-fight you'd ever seen. There were people shouting and bawling and throwing hand grenades into the Commission's thing, and it just sort of went back and they started again. Then they went through all sorts of processes. Lots of lobbying came out of that, and as a result, at the end of the day, there are derogations in the system. We'll talk about those in a minute. So there's the opportunity for derogations within the GDPR. So it's not as all-encompassing as they first intended it to be. So I have poured through this bill. It's always changing, so it's a bit of a Sisyphean task. But there you go. So what does the bill cover? You can read that as well as I can. So there's a thing called the applied GDPR, which is what they call it. And so that's the bits that are outside the EU competence. But they're under the same sort of guidance system. That's what the UK has decided to do. So in effect, they have brought into the GDPR things which are not actually in the GDPR, such as health data. So the ICO has the powers across the whole thing, the law enforcement regimes, and the same grounds for processing and derogations apply to GDPR and applied GDPR. So that's what I just said. It covers, they've effectively brought the bits that weren't in European competence into the GDPR. And then there's the national security regime. So these are UK bill which is not in GDPR, so this is stuff that's in addition to criminal convictions, treated in the same manner as special category personal data. Now GDPR allows governments of the Union to treat those two things differently. We've decided to treat them the same as special categories. Special categories, things like religion, sexual orientation, etc., etc. All those things that you remember from the DPA, probably, if you were ever involved with the Data Protection Act. All those things are in there. So it's the same. So what we've done is use the same grounds for processing as in DPA 98. And it also includes some other things, like journalism, for example. So they can process special category personal data in some cases. The insurance policy thing is in there, in the Act that you mentioned. And anti-doping in sport is also allowed. You're allowed to process special category personal data. If any of you follow athletics, you'll realise that this is quite significant in terms of the half-female 800-metre runner, I think she is, from South Africa. And there are some additional safeguards. Some of the grounds are slightly wider. So, as I said right at the beginning, the UK has taken the stance that they're actually going to apply GDPR in a wider sense than the GDPR actually demands, and actually in a wider sense than DPA did as well. So, health and social care now includes occupational medicine. Sorry?
Health and social care, just to clarify, health and social care does include everything the NHS does, everything local authorities do in social care.
That's correct.
Yeah, okay.
That's correct.
So if anybody argues the NHS is exempt from these regulations, that's actually not the case.
Well, they could be exempt from some of the regulation, but they won't be exempt from the UK bill, which basically puts them into GDPR. So that argument won't stand unless the UK bill changes radically, which I can't see it doing at this stage.
With regard to, research purposes?
Yes, okay, so...
I'm a genealogist.
Yep.
How is this likely to affect me in my research?
Don't know in detail because I haven't thought about it, but in effect, you need to put the right safeguards in place. You need to do a bit of research, effectively. Unfortunately, and I haven't done that research on that particular issue. But my guess is that if you read the GDPR carefully and the bill carefully, then you'll need to prove that you have that you really have. Well, you can't anonymize things. This is another one of these myths. There is a myth which was believed by government as well as a lot of other people that anonymization of data is black or white. It's 1 or 0. It's there or it isn't. It's not like that. It's actually a spectrum which never really approaches full anonymization. Well, it approaches full anonymization, and obviously non-anonymized identifiable data is there. So it starts from 0, but it goes asymptotic to 1 towards the end of its thing, and it just depends how much money. It costs a huge amount of money to re-identify anonymized data, but it can be done, and it's been shown to be done. In fact, it's easier than it looks in a lot of cases because you can just marry together, and this is one of the things you can do with big data, of course, marry together lots of different data sets, and all of a sudden the intersections become very few, and those intersections identify people quite often, or can do. They identify all sorts of things, but they can identify people. So you have to show that you are doing proportionate amounts of safeguards from what you're up to if you're doing research. Derogations. So what they tried to do was to try and make sure that the exemptions under the Data Protection Act also apply to the GDPR and the applied GDPR, i.e. everything that's to do with personal data. That's where they started from. Separate exemptions for law enforcement and national security services, and the existing exemptions for journalists, journalistic, literary, archiving, etc. The 5 broad classes of exemption. This is quite useful. So class 1 applies to, now this is the important thing, you've got to read this backwards. So this is for crime and taxation, immigration, information requiring disclosure under law, or illegal proceedings, and protecting the effectiveness of the armed forces. And there are exemptions to some of these things, like rectification, erasure, data subject access, for these particular cases. A bit worrying about the taxation one, isn't it? Can't go in there and alter our taxation records. But there you are. So they're in the thing. They're the class 1 exemptions. And class 2, I don't know why they call this. There's just less of them. There's less of them at the top. The exemptions are much narrower at the top, and they go down. So this applies to parliamentary privilege, things that are designed to protect the public, crown honours, dignities and appointments, judicial appointments, judicial independence, health data, social work data. Here we got that stuff. Education, child abuse. So again, data subject access exempt, rectification exempt, erasure exempt, because it's being used for the greater good. That's the idea anyway. Class 3, legal professional privilege, corporate finance. Corporate finance, that's interesting, isn't it? Exam marks. self-incrimination. Data subject access.
So confidential references.
So you can't have a data subject access to your exam marks, which is a shame, isn't it? But that's what we've done in the UK. That's part of the bill.
That subject access was a request to a confidential reference.
Nope, that's correct. That's what the bill says. These are things that we have done that aren't in the GDPR. So these are derogations. They may have changed since I did this slide. This slide was done about a month and a half, 2 months ago. And of course, they've been through various, they've been in the Lords, back to the Commons, etc., etc. So they may have changed, but that was how it was 2 months ago. Class 4 exemptions. See what they apply to. And they're, again, access request. It's all access request stuff. The references to the schedules there, by the way, in italics, are to the schedules of the Data Protection Bill, or Act, when it becomes the Act. And Class 5. So this is to do with identifying other people, you know, by putting data sets together. Again, the right of access can be withdrawn. So, essentially what they've done here in the Data Protection Bill is to put a little bit extra onto what GDPR does. So GDPR allows automated decision making in those 3 cases. Clause 13 of the UK bill says data subjects must be notified and able to request a new decision on a non-automated basis. So that's actually an extension of the GDPR, because that's not in GDPR. So all of a sudden, the UK government has become sort of human rights and privileges focus for some reason. Very interesting. And these are also in the bill. So ICO will be able to charge fees, has to produce codes of practice, and they've also produced 2 new criminal offences, which are quite interesting. So those become criminal offences. So if somebody tries to stop some of the data being pushed out after a subject access request, they are committing a criminal act. I'm not sure what the penalties are. I don't think they've been decided when I looked at this. If somebody re-identifies de-identified data, and that doesn't mean that means anonymized, not the other thing, which is, what's that called? Oh dear, can't remember the word of it. It'll come to me in a minute. There's a description in GDPR. There's a lot of emphasis on taking data away from an identifier and processing it without the identifier, so you can't actually, you know, tell who it is. Pseudonymization, that's right, it's called pseudonymization. And you would come to me if I talked about it for long enough. It doesn't talk about, that's not about pseudonymization, that's about re-identifying anonymized data. So, for example, if you've anonymized data for a big health research project, which is one of the things that is allowable. If somebody then takes that data and re-identifies individuals, and health research is quite easy to do that, relatively speaking. I mean, you or I couldn't do it, but it's relatively speaking easy to do, with especially in rare diseases. And then that person was targeted for whatever reason to sell a cure or whatever. I mean, this is a ridiculous example, but I'm just using it to illustrate the point. And that would be a criminal offence, the person who did that re-identification, or organisation that did that re-identification. So, there we go.
Another question there is, like Strava data was put out as anonymised, and it was very quickly identifiable to individuals. So in that case, would the people who identified them be criminals
Yes. In the future, yes. Oh yes, certainly.
Is it on? Okay.
Nearly finished, by the way.
Does this actually make the Scottish Home Report illegal? Because
What is that?
The home report, which is when you sell your house, you have a home report based on its value and everything else. On that home report is actually your signature, and it's released out to the public.
I don't think. Well, it doesn't make it illegal because you presumably consent to it going that way.
No, you
if
don't.
If you want to sell your house,
you have to legally provide a home report.
Well, then it becomes.
But you don't consent for your signature to be on it.
I believe that there might need to be a little tweak in the law, but it would be a legal. It would be a legal basis other than consent. It would be one of the other legal.
Oh,
bases.
I see.
Yeah.
But it's personal, isn't it? Your signature. Very.
Well, yes, except you only ever use it in your real signature, your full signature, in sort of impersonal or outside situations. So I think that would come under a different. It wouldn't come under the consent law, so it would come under a different basis. Probably, I can't remember what they were now. I'd have to go back to them. But there's one about the law of the land, effectively.
Interesting.
So that's more or less it. I'll just do a couple of cartoons that I found. This is what the future is going to be. No more payment protection insurance people, but very rich people. And then, of course, there's always the that's it scenario. That's today. The vultures are coming. And the other one I found was this, which unfortunately is not true in my case. And then with a bit of munch. So, sorry, you were going to ask a question. Do you want to do that?
Statements of special educational needs come under a class 4 exemption. What exactly does the exemption apply to? Is it the data held in that report, or is it everything that feeds into that report? Because usually multidisciplinary and multiple professionals contribute to that report, and they will hold data in their own respective databases. So is it everything pertaining to that report, or is it only the report itself?
My belief is that all of those people will be data controllers in their own right of the bit that they hold, or the bits that they hold, the information that they hold. So they will all be, all of the contributing information will be subject to the, well, it may be subject to the exemption. It might only be when it's aggregated that it becomes exempt.
Yes.
But they will all be data controllers in their own right, including the people who hold the aggregated report, which almost certainly would be exempt. Mm-hmm. So they're all data controllers in their own right. They can't be considered processors. They do process, but they are the controllers of that data, the individual organisations. I think you've put your finger on an area which I think is going to be very difficult, because okay, so this comes back to my point that although we should have been doing all this, and I've alluded it, we should have been doing this for years now. We've known this is coming for 2 years. We should have been doing a lot of work about it, and people are beginning to wake up now. I don't believe that the regulator is going to be. They might actually take action, but they're not going to be very hard on people who are not really big fish. I'm not the only fish in the sea. But the big problem is going to be vexatious and crusading people. And of course, in the area of special educational needs, lack of perceived lack of proper dealing with people with various sorts of disabilities, mental health issues, and such. So there are people who crusade about that, and they may try to cause trouble by bringing this forward. And in essence, in answer to that, you haven't really got a prayer, because you should have been dealing with those very issues you're talking about that, the sort of thing you're talking about there over the last couple of years, working out just where it sits, how it works, and what you need to do. And I don't know in detail in your case, in the case that you've just described, but I would imagine that everybody there would be a data controller of their information. You need to decide where the information leaves one and goes to the other. Did it need to be transparent to the data subject? Perhaps not. Perhaps, or all of those things should have been looked at in some detail. I don't know the answer to it because it's a difficult case, but it should have been looked at.
As you say, much of it is interpretation, and in the comparison of public versus private sector, take healthcare as an example. If a doctor were to make a recommendation to notify, let's say a GP, notify all their patients about a flu vaccine that's coming up, it would be in the public interest that they're doing that.
Indeed.
That is understood. But if a private clinic were to do exactly the same, it may be construed as touting for business, so to speak.
Yes, unless of course they had used a really transparent privacy notice when they gathered the information, said we may use it to. It's the old marketing thing, you see. The marketeers are going to have an interesting time with this. So that we may use this to contact you to tell you about things which we think would benefit you. Do you agree? So they'd have to opt in, because there's no opting out anymore. Opting out's gone after May the 25th, which you'll probably find interesting. Sorry to go off the topic here, but even today I'm still receiving things which say, complying with GDPR, if you want to stay as it is, don't do anything. That is completely wrong. So anybody who's done that is immediately non-compliant with GDPR. But I'm getting lots of those. I got 2 today, from people I normally get feeds from. So, yeah, I agree with you. But again, there are ways of dealing with this, and that is to do with I haven't really talked about privacy notices, but there's good guidance out there about what should be in a privacy notice, and that doesn't just apply to commercial organisations. It applies to government and quasi-governmental organisations as well. So I'd advise you to have a look at those and make sure that your privacy notices comply.
Sorry, the very problem here is whether it's an NHS GP or a private GP, that GP has a duty of care to that patient, and so they may well be advising in the interest of the patient. And if they were to give that patient an opt-out to such notifications, that private GP is not providing holistic care, and the GMC would take a dim view that you're not informing the patient of something that is a serious risk, knowing that they have underlying medical problems like asthma or whatever else it might be, and they're at high risk of serious flu. You have a duty of care to inform them. The very fact that they have opted out does not absolve you of your responsibility in terms of your duty of care. That's the problem.
Are you a GP by any chance?
No, I'm not. I am a doctor though.
I'm a parent, my son can't communicate. So if you trying to provide the my son can't communicate, so we have to decide for him because he can't decide. So are we opting in for him?
Yes, and almost certainly that would be allowed, but I don't think it's actually covered in the GDPR as such. There are things about children.
But it's one of these things.
But it's one of these issues. There are a huge number of them. I mean, in essence, the whole business of using AI and big data and what you're dealing with to look after elderly people in their own home, which actually implies a degree of surveillance and automated decision making, and not automated decision making, but there's an awful lot of personal data which is floating around to have that to happen, which in essence is a good thing.
Yeah.
But it's one of those areas which is going to be played out as we go forward. I really don't think that silly decisions will be made. There will be some silly things that happen, because there always are when you're dealing with governmental organisations. But I really don't think that over the long term that silly things are going to prevail in this sense. I'm quite optimistic about it. I don't see it as a fear, uncertainty and doubt thing. I see it as being something positive which moves at least some of the weight of use of personal data back to the data subject themselves, which is a good thing.
The gentleman's question is actually relatively easy to answer. Lord Fraser pretty much summarized it that unless the person is a minor below the age of understanding, then whoever is the guardian, they have responsibility for consenting on their behalf. If the child is of sufficient maturity and understanding for understanding the consequences of their actions, then they can consent. If the person is not able to speak, as you're outlining, then whoever is the nominated guardian in that person's stead, then they do carry that authority for consent. So it's actually fairly clear cut in that particular scenario.
Thank you.
Quick question. I wonder if you could clarify something. I've heard that the current requirements for data controllers to register with the ICO may change, and there may not be a register. Is that correct?
I don't know, but you could easily find out on the ICO's website. Okay. I haven't looked at that. I think I have heard something that there is a change, but I'm not sure what it is. So I'm sorry, but you'll easily find that on the ICO website, I'm sure, if it is happening. At the moment, you still have to register.
Can I just say we're getting up to 8:30 now, so we've got a couple of quick questions to finish off, and then we'll be, I think there's 3 people who've raised their hands, and then we'll be closing off the evening. Otherwise, we'll be here till midnight trying to solve the issues that are GDPR. Thank you.
Well, I hope I haven't got across that it's as bad an issue as, I mean, a lot of these things look very difficult, but it actually will be more pragmatic in the way it's dealt with, certainly by our regulator, I'm sure.
Yeah, regarding consent, paid membership of a private club, could that be assumed to have been
You
consent?
can never assume consent.
No.
No. So I'm involved in a couple of those, and we are going out now to our members saying, you know, opt in, this is what we do with your data. We're doing a privacy notice effectively. We're saying, this is what we do with your data, this is what we intend to do, this is how we keep it, this is how we store it, this is how long we keep it for, and we use it for these purposes only. Please say yes. If you say no, then we'll stop charging you for belonging to this private members club and you won't be a member anymore.
Could that be held off until the next renewal comes along?
I wouldn't advise it, but
No.
I wouldn't advise it in case you've got somebody who's you know, being awkward or being difficult. And there's, in any organisation of more than 100 people, there'll be at least 2 of those.
Thank you.
Hi, do you mind if I ask about kind of historical data or legacy data? See data that's already collected.
Still personally identifiable
yeah, it's
information.
Still there. Will anyone have to notify it's been destroyed or what they're destroying?
Okay, so when it was collected, you should have said how long you were keeping it for, etc., etc. And if that changes under GDPR, you'd have to tell them that it's changed and that you're keeping it longer for whatever reason, unless it came into one of those exemptions, in which case you don't have to. But
yeah, sorry,
I've got somebody's hand up over there. I thought you were trying to tell me something. So yeah, you have to treat. This is the problem. I've tried to allude to it a number of times with legacy. There's legacy systems, there's legacy data, but it's all under the GDPR if it's personally identifiable information. Yeah. So you have to deal with it as if it was new data.
But if you were destroying that data because you didn't want to retain it, you'd have to notify someone that you're doing that, or
I would say that would be best practice. You probably, I can't say for sure that you would be had up for doing that, but I don't think you would.
Okay, thank you.
It would be best practice to tell them that.
Speaking as a genealogist, I kill you.
One question for me also. You mentioned earlier the concept of data portability. Can you elaborate a bit more on this? For example, is there a standard governing the data portability?
Unfortunately not. No, this is one of those areas where the GDPR is vague. It says that you must have it in a machine readable format, which is generally available, and that people can therefore move it from one provider to another or keep it themselves as they wish. They should be able to get hold of it, but it is not defined. There is no defined standard. Now, this might be one of the areas. There's a whole bunch of stuff at the end of GDPR which looks at the possibility of coming up with standards, but this has not yet happened.
So, for example, anyone can ask your organization to provide your set of data on his own desired formats, or
not unless it's something which is in general use.
Okay,
you might be able to get away with it if it's in general use, but if you're not, if it's something that he's personally invented, then no.
Okay, thank you.
At the back, with the underlying principle of transparency, would that undercut some of the thought projects going on in regards to AI processes being used in job hiring, do you think, in making that more transparent?
Absolutely. I think that one of the big impacts of all this is going to be on AI, big data, and all of those things that are so prevalent now. It's going to be a bit of a fight.
And how much effort would companies, say TV manufacturers, have to put into updating their older models, say even 5 years old, 10 years old, to comply with GDPR for doing opt-in in a clear manner and say in their voice recognition, do you think?
Yes, they should have always been clear about what they were doing about it. I would think now, and obviously they haven't, we know was it Samsung or something, which was recording everything that happened in your living room and all that sort of thing. Yes, it's really the same answer as I gave here, that what should be happening is that legacy data should be treated the same way, but it's part of the problem that I alluded to before. That's a particular system which was designed before this happened. Although you could argue that even under the directive it shouldn't have been like that, but it was designed before, and therefore it's going to be hellish difficult to comply going forward. That wasn't swearing, was it? He warned me not to swear before I started. So it's going to be difficult, but in principle, what you have suggested is what should happen. In principle. But, there's so many things of that nature that are in existence in our legacy. I think it's going to be very, very difficult. It'll probably depend on the whim of journalists, of crusaders, and of the regulatory authorities, which ones actually come to the fore. We live in interesting times.
I'd like to thank Ian very much for not only coming up to Glasgow, but for that very interesting talk on GDPR. And I'd like to thank him for me, clearing some of the fear, uncertainty and doubt. And I think actually GDPR will be good for us as individuals in the future. It might be hard for business, but I'm sure we can work around that one. I'd like to just give Ian a big round of applause. Thank you. All right, Will's going to give a brief.
Yes, so that concludes our event for the evening. Just some house business. We don't have any more meetings until our next session starts in September. So look out for the second Monday in September. Our meetings are all up on the Open Tech calendar on our website, on the BCS website, and various other places. You can follow us at BCS Glasgow on Twitter and BCS Glasgow on Facebook. So keep an eye out for what we end up doing next year being September start, and hopefully we'll see you again. Thank you very much.
And we do have a LinkedIn account.
Interesting time. Thank you.